let me welcome everyone to this CLE, and I certainly think there's a tremendous amount of value to be gained from this conversation. There's some people in our community who are really leaders. There are people like Phil who have, if they are willing, have enormously important lessons that they can share with us about this mystery of the practice of law. I teach civil procedure and I teach evidence, courses that really relate to litigation, and I litigated myself for over a decade and a half. And I am in profound awe of people who can do this skill with style, with professionalism, and legitimately serve the cause of justice and their clients. And when I meet someone like that, I can really appreciate it. And Phil is the second person who we've asked to do this. And just to give you an idea of the caliber of people that we would even consider for this, the first person was Henry Miller, who is one of the nation's leading trial lawyers. And I have to say that Phil is right in good company with Henry. Phil is a magna cum laude graduate of Fordham, and I'm proud to say an alum of the school, although not a student of mine.
No. You weren't here?
No, I wasn't at the school. Some people think I've been here forever, but not quite forever. And he then clerked in the Southern District of New York with Irving Ben Cooper, a United States district judge, who was a district judge for many years. Appointed by Franklin Roosevelt?
No, he was a judge for more than 50 years, but he was appointed by John F. Kennedy.
Oh, was he really? Okay.
He was a magistrate judge in criminal court.
And then was appointed. So Phil clerked in the Southern District of New York, and then he's gone on to I won't go through all his credentials, but he's gone on to an exceptionally successful practice of civil litigation. One of the few civil litigators that I know who's actually had a lot of trial experience. How many?
Well, I stopped counting, but I'm certainly well over 100.
Yeah. And so Phil and I we've gotten together and I've really enjoyed it over the past 6 months to sort of chat about this. We had lunch this fall in a nice place, and then we've had several lunches in your office, which aren't as nice, but it's been he bought me a sandwich, and in those conversations we talked about what are the lessons you've learned? What is it that you would want to talk to an audience like this about? And from those conversations, Phil has distilled 13 keys to successful litigation. And we're having that conversation with this person who is a highly skilled, successful civil trial lawyer about litigation and about how one brings the concepts that one learns in law school and puts them together in a way that really serves people and as I say, serves the cause of justice. So what we're going to do is we're going to do, the format is we're going to do this through a conversation and going through these points. And I'm going to try to leave us some time for questions at the end. So here we are. We're together again, and this time I have a PowerPoint. So you said that the first skill is always think like you're in the courtroom.
True. What we're going to talk about is the way I live my professional life. So I don't say it's the right way or the wrong way. This is the way I do it. And so I don't subscribe to any point of view other than I'm trying to get better at this job. I've been doing it for 30 years, and I've done it in a lot of states and in a lot of contexts. But I'm trying to get better. So if I learn something tonight from our dialogue, that will become my way. I have no pride of authorship about what I say and what I do. I'm just trying to improve the skill set. So that's where I come from. And so that doesn't make me a master of anything. It makes me somebody who's trying to get better. So that's my point of view on things. So the first point we talked about was always think like you're in a courtroom. So if you've never been to a courtroom, and I suspect some of you have and some of you have not, you need to go there. You need to actually go and sit in the room. When I argue appeals, I've been to the Court of Appeals in Albany a couple of times. I actually plan about 4 months ahead to go there and sit and watch and learn the dynamics in the room. And that panel, that group, has its own dynamics. And it has, you could argue about the junior justice or junior judge and the senior. You need to see what happens in that room in order to get comfortable in that room. You need to walk up to the podium and see what the podium looks like. Is your notebook open? Can you get comfortable? Is it too low? Where are the lights? You need to actually do those things because that's where you're going. I also say think like you're in the courtroom because it makes things simpler. If you're my client and we're about to have a privileged communication right now, tonight, and you're all in the room, I can't do that, right? Because we don't share that privilege. Now, if you're an accountant and you happen to be there, is there a way to have that privilege come? Of course there is. But if you're not thinking that way, you could lose a very important conversation to your adversary. So why would you do that? You wouldn't do that. Nobody I know would do that. How you present yourself in the courtroom also impacts on your gathering of evidence. Pieces of paper that might not be important to somebody who's not thinking like they're in a courtroom become very important to somebody who's thinking that way. Ordering your proof, finding out which documents, which witnesses, the order in which you speak to those witnesses, all becomes critical from that mindset. It's not the right way or the wrong way, but if you think that way, when you're gathering evidence, looking for witnesses, having telephone conversations, making notes, trying to create a fact pattern or defend against the fact pattern, knowing that you're going to stand in a room with those pieces of paper becomes important.
So you're saying from the first time you meet a client, you're thinking...
I'm gauging the way they look, the way they dress. Are they appropriately dressed? What do I... Part of thinking like you're in a courtroom is reacting to that person. Asking tough questions, seeing what reaction you get. Are they looking you in the eye? Are they kind of fumbling around? Do they have that Rolex watch on and the big diamond ring that no juror in this state owns, statistically speaking? Are those Gucci shoes? Do your socks match? How come you have that gray shirt on tonight? What is it about? Those are all how you look, how you articulate. Do you have any tendencies? The more you do litigation, actually, it gets more interesting because it evolves to personality. It evolves to who's telling the truth very often in complicated sagas.
Where did you learn this? I don't have this on my syllabus.
I'll tell you what happened to me. I graduated from Pace Law School in 1980. And this is a true story, and it's worth digressing.
Were you in the first grade?
I was in the second class. And, I had to work my way through law school. I didn't have anybody to pay for law school. And, I thought I was going to be in the golf business. So I came here because it's 8.2 miles from the club I worked at. And, I wasn't always going to be a lawyer. I just wanted to keep playing golf and going to school. So I did okay, and I taught legal writing, and I was Jay's research assistant. And so I guess we had a committee that said, if you would like to be a law clerk to a federal judge, or any judge, actually, I'm not sure it was just limited to the federal judge, fill out this application. And I did, and I sent it in, and I made it, and I sent my resume to 5 judges. And it actually turned out that the 5 judges had already died. So I went back to the committee and I said, I'm not feeling warm and fuzzy about this. Could we do, well, I'm sorry, it's luck of the draw. Not a lot we could do.
You didn't have any rejections.
I didn't get rejected for sure. So I had taken a bar exam, and Judge Cooper's chambers called Jay actually, and Jay called me and said, would you mind if I sent your resume to Judge Cooper in the Southern District? I said, Jay, would I mind? I don't have a job. I've got money to pay back for education. I'm getting married, and would I mind? No, I wouldn't mind. So I went and went through the process, became his law clerk. So I spent 2 years and another year after I left.
That's an interesting story too, which we don't have time to tell. But
I spent 2 years.
How you got that job was a really fascinating story. But go ahead.
But he taught me. He taught me. He stopped trials.
Yeah.
We had the British robbery. We had Galella against Onassis, which some of you may remember, the paparazzi, some of you never heard of, I'm sure. But he would stop trials, and we'd go in the roving room, and he'd say, stand over there, and now you're a plaintiff's lawyer. What do you want to tell me? All right, you just heard that. Now go over there and be the defense. So I learned so much, and my deal with him was, I said, Judge, I'll work 7 days a week as long as you teach me everything you know about the case, because I got enamored with it. So I probably got decades of experience at the beginning of my career that I just fell into. It wasn't my genius. It was me getting lucky, and my law school standing up for me, Jay Carlisle standing up for me, and pushing like they do for all of you, I'm sure, and they will for all of you. That's how I got into it, and gauging people was a large part of what the judge taught me, and so that's kind of how this first point started.
You also had on this first point privileges and drafts.
Privileges are similar to the ones that I was describing about maintaining the privilege and not losing the privilege, because it becomes your own war within your own mind. If you know you had an unprivileged, non-privileged communication, and for example, we wrote memos back and forth and copied the non-lawyer accountant on it, do you turn that over? Well, you have to turn it over if you asked for it. You want to maintain and protect every privilege, not just the lawyer-client privilege, but any privilege. Drafts means some of the best evidence I have found is drafts of the documents that end up being the critical documents.
Right.
And everybody says, oh, drafts are parole evidence, not admissible. But that's not what parole evidence really says, right? You can't admit documents or drafts or copies to modify or alter the terms and conditions of the contract. But you can always offer them to explain to a judge what the parties meant. A subtle distinction.
So what are you saying though about drafts? I mean, you're saying that they have a potential danger.
They have a potential value.
The other party's drafts, but your draft.
The party's drafts, my drafts, anybody's drafts. That's the first file I want to see are the drafts, because in there could be buried clarity. People don't fight at the level I'm fighting over for $20. We're not fighting over $20 or $100,000. We're fighting over significant problems.
I want to say one of the verdicts I neglected to mention that Phil had was a $168 million verdict, which was the judgment.
128. I wanted 168, but I got 128.
Should have been 168.
It would have been 168. But the point is, if you don't think like you're in a courtroom and you recognize the validity of the thought that drafts of documents can help you, you're going to bypass them. Oh, those are drafts. What the heck do we need to look at those for? Well, if you're in a courtroom and you know that you can use a draft to explain to a judge what the language that you're fighting over, because you're always fighting over something, means, and you can get it particularly from the other side's file, you're establishing your fact pattern. So what I meant was, if you think like you're in a courtroom, you'll treat the documents you get with the proper etiquette, and you'll search them for what it is you're looking for. Not an easy task. It's boring sometimes. Okay, so I mean now I got 600,000 pieces of paper. Imagine 600,000 pieces of paper. We looked at every one of them. Because we're on a mission. We're looking for something. So that's what I meant by thinking, staying in the present tense, staying like you're always going to go to a courtroom. What can I do with this? How can this help me? How will it hurt me?
So you talk about how you're sort of projecting yourself in there because there are things that you're going to do now if you don't have that mindset. Is what I'm hearing you say. If you don't have that mindset, there might be things that you can do in this very early stage that will hurt you.
Every case has a theme. Every case has a storyline. Every case has its own idiosyncrasies, its problems. You need to spot them, find them, defend them, protect them, give it your best, particularly when you're getting paid to do this.
Right. So that is it fair to say then that anytime you meet a potential client, you're thinking of litigation? You're never not thinking.
They're not coming to me if they're not.
Even though most of the cases aren't going to go to litigation, or is that wrong? You're thinking about trial.
You're thinking about how can I use this in a courtroom? Yeah, I start my case preparing day one to get into the courtroom.
Let me ask you this question, and let's go on to the next one. One of the hardest things for me in litigation was doing all the things you're saying, but in the back of my mind knowing that it would only matter a tiny percent of the cases to do all those things. And then, you know what I'm saying?
Yeah.
And then to find the energy to do all of those things, even though many times those things that I did wouldn't be necessary. Do you deal with that? And one of the things I find about being a law professor is so much more easy, is everything I prepare for, I do.
Yes.
But when I was a litigator, there's so many things I prepared for that I didn't do. Now I can see, well, go ahead, you get my point, right?
I think you're saying two things. I think first you're saying statistically, 95% of the cases that are brought settle.
Right.
So that's one thing you're saying.
Right.
I also think you're saying there's a gradation between and among fact patterns. The $10,000 case shouldn't warrant the same amount of attention as the $10 million case. In the sense that...
I wasn't saying that, but I hear the point. Yeah.
In the sense that it's not economic.
Right.
So let's do one at a time.
Yeah.
The first thing is that statistically 95% of the cases that are brought in state and federal court, generally, I don't hold me to this number, it's a pretty accurate number.
Yeah, it's 96.
Settle. They settle. And they settle for a variety of reasons. The cases that I settle because they need to be settled, and the client wants them settled. But the cases that I settle are settled because I either have you by the lungs, and I'm not going to let go. I'm not going to let go unless I stop breathing. Or I need to settle because we're going to lose, and we've assessed our risk. I would only disagree with that thought that, well, if they're going to settle, most of them settle, why do all the work? Well, 5% of the cases don't settle.
Right.
At the point I'm at, some of my cases do settle, but they only settle when we have something to talk about. And the only way you get something to talk about is when both sides have risk. And the only way you get to mutual risk is when you have a 2x4 to the other guy's forehead that's clear as a bell. No matter what, ranting, raving, hollering, you've got him at risk. And when you're a plaintiff chasing money, and the other guy knows he owes you the money, but he's not going to pay you this year because he can pay you next year, to get into that dialogue requires something. And we're gonna hit on this a little bit later when we get to the burden of proof.
Yeah, let's go to number 2 because we've spent about a third of our time on that.
Okay. Well, let's pick it up, Michael.
So the second one is trust no one.
Yeah, it's not paranoia. It's not. We should identify. It's not paranoia. What I mean by that, trust no one, never be disappointed. People that work for me, I say this all the time. Can we make a stipulation that these documents are going to be admitted into evidence at the trial? And you say, sure. Well, trust no one, never be disappointed. To enforce that, we need an order of the court. So we need to enter into an order and stipulation on those particular documents. Oh, but I'm a person of my word. You are. And I accept that, but I'm a lawyer, you're a lawyer, and we have clients, so we don't have to trust anyone. Let's just do it the right way. Trust no one, never be disappointed.
You make a distinction inside and outside.
Trust no one, never be disappointed. I submitted this week a Rule 19A statement, which is a statement in support of the summary judgment motion. And we decided to reduce the size by double-siding the copies. So, trust no one, never be disappointed. One of my lawyers sat down and looked at every page that the judge is going to look at. And lo and behold, a page was missing. And another one got stuck in a copier and kind of came out sideways. Well, if that's what I serve up to my judge, and the page that was missing, fortuitously was the critical page in the agreement that we were arguing over. Trust no one, never be disappointed. Yeah, it takes an extra couple of hours to make sure that's right. The copy guy's doing his level best. He doesn't get it. That's your proof. That's your calling card to your judge. That's one of the ways you tell a judge, I'm the most reliable guy in the room. I may not be right, Your Honor, but I'm going to tell you the truth. And when I serve it up to you, it's going to look right and feel right. Trust no one, never be disappointed. We e-file now. Very interesting. This week, first time I had this. We e-file our brief in support of this motion for summary judgment. You scan it, you send it in to the e-filing. Guess what? One of the pages of my brief didn't make it through the scanner. I don't know why. I barely know what to do to scan myself. But it didn't. If we hadn't checked it, what does that tell a judge about the level of care and concern I have? Proofreading. Proofreading. The worst job a lawyer has is very difficult. You need to proofread. Every typo, every mistake is just a reflection on you. Is it the end of the world? Absolutely not. But if you're serving it up and a judge says to you, by the way, Mr. Halpern, I read your brief and I thought it was beautifully done, and frankly, I haven't gotten one without a typo in it in a long time. Thank you, Your Honor. So what are we doing? We're communicating on a very professional level. That gives you credibility in the room. In the room, you need to be the most credible person if you want to win. So trust no one, never be disappointed. You need to approach everything that way. If your name is going on it, that signifies something to the rest of the world. Whether it's a 2-sentence, 2-page, 200-page, it doesn't matter. It's your name, your reputation. I earn my reputation, and I earn it every day. And I'm very protective of my reputation. I'm not willing to compromise it for anyone, nor a typo, nor an improper argument. No, I like to play by the rules. Do I push? Do I fight? Do I raise my voice when I think it's appropriate? Of course I do. Of course I do. And most importantly, you'll have this, all of you, particularly the younger, the older people here realize what I'm saying. At some point, people begin to work for you, God forbid, and you actually are not the lowest person on the totem pole, and they actually inundate you with things to read and sign your name to and get to, and you need time to think. And that person could be the greatest writer and the smartest kid from Pace Law School or Harvard Law School, I don't care. I prefer
Pace Law School.
I prefer the Pace Law School, frankly. But you need time to think about what's going on and what you're signing your name to. I don't have to trust you because you're working for me. I don't have to trust you because I've given you an assignment and I'm paying you ridiculous money to, no, I shouldn't say that, good money to do your job. I need to think for myself. And so it's not a paranoia.
How do you find it? How do you do
You make time. If you're doing this job, you make time, and you live nearer to your home when you have a family because your family has to come before your work, and you sacrifice. You get up early and you figure it out. You know, you figure it out. But this is a calling. This is not a job. This is not a 9 to 5 job that some of you will.
Well, really, one way I would summarize what you're saying is sort of the buck stops here. You can delegate, but you can't really delegate. Ultimately,
you can delegate, but you're responsible for your own result.
You've got to figure out a way to retain your responsibility for it. Now, you had on the outside, confirm in writing what we talked about, not trusting people, no matter what you think of them. That's just sort of a blanket rule, right? Because
it's your obligation to your client.
You do that even with me, if I was on the other side.
I've had, Tony Santone and I have had a matter where we were adversaries. We lectured together, Professor Santone, some of you had. Brilliant guy, New York practice, arm's length. No, we're not relying on each other. I protect my license. I have an interest in doing this for a while. I have no interest in having people complain about me professionally. You didn't do this, you couldn't do that. You know, you get to some of the finer points if we had more time about strategy and trials and what's a client decision and what's a lawyer decision. Trust no one, never be disappointed means if you walk into a courtroom for the first time and you get up and you haven't been there before, and even if you don't go there half an hour early to see how's the judge today? Is he in good mood? Is he in bad? What are his pensions? This particular judge doesn't like it. Another judge likes it. You're not allowed to sit and talk to a judge. You got to get your fanny out of the chair. I can't tell you how many times I've seen lawyers get wiped out before the counsel. Stand up. Stand up. You're not paying homage to the king. It's out of respect for the court. You're an officer of the court. You're supposed to know that. You're supposed to understand.
You know, we saw an example. Was anybody here in my Civ Pro class last semester? No? Yeah, remember last semester we went to court? It was exactly what he's saying. Those lawyers had not gone to the court before and didn't know. They were state lawyers, they had the state practice. Both those lawyers were state litigators, and they had a case pending before Judge Smith in the Southern District. And they acted as if they were in the state Supreme Court. And they hadn't done exactly what you're saying. And it made an impression. And had one of them known and the other not, that one would have had a real advantage. But it turned out neither one was a wash because neither one did. Well, we need to move to the next one. The burden of proof is everything. And I have to say, this one reminded me of what I try to teach my students. I think this is many of the things you're saying And we ought to talk about how you learn these things. And you say you learn them by being a clerk in the federal court. I mean,
That's how I started.
we don't teach how to look at someone's socks and all that. But,
Yeah.
but there are things in law school that are very valuable lessons for litigation, and I think this one really is one that has that is taught in law school, and that you really validated when you made this one of your key lessons.
So this is the essence of litigation, and it's universal, and it's criminal or civil, it's administrative or judicial. Everything has a burden of proof. Every claim, every defense, and each claim and each defense, and sometimes lawyers mix up, is it a claim or a defense? And they mix up, is it a cause of action or a remedy? But each one has elements. Each one has a burden of proof, each burden of proof has elements. It's the articulation by judges over time of what you need to plead and prove in order to sustain the claim or defense. Just that simple. No one should approach anything ever without knowing what the burden of proof is. If you know the burden of proof, you know what you need to plead, you know what you need to prove, you zero in on the type of discovery plan you need, you can think through who you need to depose, what documents you want, do you want to ask for interrogatories or not? How are you going to frame up your deposition questions? I took a deposition once. I went with a young associate. I said, I'm going to be 20 minutes. We're going to get in and we're going to get out. This guy who's still working for me, working with me now, a partner of mine. He's been with me 20-something years, I guess. He said, what are you talking about? I said, just watch. I went in. I had my burden of proof. I asked the 20 minutes worth of questions that I needed to establish that there was no oral agreement here. I stopped the deposition. The lawyer on the other side said, are you done? I said, yeah, I'm done. Yeah. He said, you're kidding. I said, no, I'm not kidding. We went back, got the transcript, moved for summary judgment, case dismissed. Why? Why spend all that? You don't need to if you know the burden of proof. If you don't know the burden of proof, drafting a complaint is impossible.
Right.
It's impossible. Why would anybody not want to take that time at the beginning of the exercise to learn what it is you need to plead and prove? Motions to dismiss. I've got, sure, plenty of motions to dismiss in my time. I don't misplead. They don't dismiss my pleadings. No one does that to me because I've done my homework. My discovery plan, and that's part of, as you build a business and you have more cases, you can go down the hallway to somebody and say, okay, we know what the burden of proof is, we know what the discovery plan is, go execute it, and if you deviate, so much as a foot, you got to come and talk to me before you go any triggers. If you deviate from our plan.
From the plan. Which is key to what the law is, to the burden of proof. It's in the elements
it's everything.
Of the case. That is so simple and so critical, and it's so amazing why people don't get that.
There's no brief I write that the first point, every brief I've ever written, word of proof.
One way to look at this is to say every class in law school is about that, except for civil procedure and evidence. I mean, that's what they're all about, the elements and the burdens, right?
I couldn't agree.
I don't know what else they're about. We're going to take questions. We're going to take questions at the end. But so this helps give you the focus.
So
that's essential.
And you need to do it at the pre-pleading stage. Those are in the notes. And the other point is, so you have a Title VII case. There's discrimination predicated on age. Okay? And one of the elements is an adverse employment action. So, what does that mean exactly? Adverse employment action. Well, certainly common sense would say, you're fired, that's pretty adverse employment action. What if you're demoted? What if you're passed over? What if you're pushed sideways in the organizational chart? You actually have to know what these words mean. Identifying them is step one. Understanding them is step two. And that's why the law school you're in is so terrific. Because there's no pride here about winning and losing. There's a pride about instilling the right professional values. Evidence, J. Carlisle, criminal law, all of them are teaching you how to be a lawyer. It's just that you haven't used those tools yet. And you're exactly right. Every substantive course you're taking is about the burden of proof.
Do you have a sense of why? Let me ask you this. Is it your sense in practice that a lot of people that practice, that litigate, don't have that understanding?
Did we say these were secrets?
No.
We should have.
You said they were keys.
We should have, because I'm going to be honest. I'm a very loyal to our profession lawyer. But I have to say that the zeal is not across the board. The work ethic is not across the board. If you want to distinguish yourself, you need to work hard at this job. I'm not really sure why I'm here talking to you tonight, frankly. But the truth is, I'm trying to get better. The truth is, I enjoy what I do. I don't work. I'm a practicing lawyer. It takes time, it takes practice, but this is how I do it. I don't do it any other way, and I would strongly encourage you to reflect. You know that burden of proof is everything, and by the way, it makes it easy. It makes it simple. It demystifies the funnel of, oh my God, I got to bring a summons in. It gets simple.
Can I say something? That's what I was going to say. I was going to say sometimes the most important lessons are the simplest.
Yeah.
And this is such a simple lesson, but it is so important. Let's go on to another one.
This is one of your favorites.
This is one of my favorites.
This is one of my favorites. Rules of evidence are your friends. Said differently, why do we have hearsay, and why do we rely on this kind of archaic, we want the truth, the issue of truthfulness? Why do we really need hearsay?
We have the most complicated evidence law in the world.
But
that's a true statement.
It is, and it's not all in one place. There's common law, there's the Article 45, there's the Federal Rules of Evidence, it comes from a lot of places, but no differently than we speak to the burden of proof on a claim or a defense. The rules of evidence are your friends. I mean, it's a tool. It is the most powerful tool. I cannot tell you how embarrassing it is to watch a lawyer with a piece of paper that has to get into evidence, and he can't get it in. He doesn't know how to get it in.
He doesn't know the foundation.
He doesn't know the first question. This is a business record. Is this record made in the ordinary course, kept in the ordinary course? Was it made at or about the date set forth in it? And in the federal court, are you the custodian of it? That's all you need to do. He can't get it in. If that piece of paper doesn't go in, the judge learns two things. That guy is not sharp. That's the first thing. That's a very important thing. Very important thing. And that evidence doesn't go in. So, you need to make a roadmap. You need to make a roadmap for yourself. I have a case now that is, this 600,000 piece of paper case. We're down to probably, 1,500 pieces of paper. The next thing I'm doing is I'm making my roadmap for my evidence in a courtroom. You know, if you want the certificate of incorporation in, it's got to be certified. It's got to have the magic stamp and the magic words. Why? I have no idea why. No idea why, but it's badges of truthfulness. It's indicia of reliability. It's tomorrow I'll be in Manhattan defending a non-party witness in a case, and I guarantee you that half the questions they're going to ask aren't going to be answered. Compound, Your Honor. Assumes facts not in evidence, Your Honor. Asked and answered. You asked 3 times, Your Honor. You heard it the first time I saw you make your notes. I know you heard it. You're right, counsel. You're right. You're right. They're your friends. They're a powerful tool. The first case I tried in my life was a broker's case. I was in New York City Civil Court. I was the plaintiff, representing the plaintiff. The defendant, I put my case on in 2 hours and 30 minutes. The defendant got up, he asked 128 questions. I objected to 118 questions, and I was sustained 118 times. This guy, my senior by decades, finally said to the judge, "If you won't let me put on a defense, Your Honor, I'll just sit down." Fortuitous. It was one of the best learning lessons I ever learned. Can you get away with that every time? No, but I was a kid. And that judge knew I was a kid, and he was getting a kick out of the fact that I was so thoroughly prepared that I was beating up on the gray hairs. It worked that time. Can you be a pain in the neck and object to everything? No. Sometimes they're your friends, so it's dynamic. Sometimes you've got the best objection in America to the piece of paper, but guess what? You want that piece of paper. You want to take that piece of paper and put it where the sun doesn't shine when it's your turn, okay? So you don't object. You don't want to. Oh, no, Your Honor, Mr. Halpern, you sure? Yes, Your Honor. And then later on, when you begin to pound with that piece of paper, you get the look. Ah, now I understand what you're doing. And you're beginning to have a dialogue that's dynamic. You're beginning to show the judge, I would never hand Your Honor a piece of paper unless it had a certification. I'm sorry it's on the last page because I thought that's where it belonged, but if Your Honor wants my certifications on the first page, just give me 10 minutes. I'll go in the hallway and I'll restate. Oh, no, Mr. Halpern, that's fine. Oh, you're sucking it up? No, you're not. No, you're trying to win. You're trying to win. Figuring the rules. So the rules of evidence are your friends.
Can I ask you this? I've lectured on evidence to judges, and without casting aspersions, there are many fine judges, but there are many judges who don't really understand the law of evidence. So have you found that to be so? And
Are we taking this?
I guess as a professor, I keep saying
not.
There are these little outs that judges will have, like if it's said in the presence of the client, then it's never hearsay, things like that. These little,
yes.
Right. And how do you deal with that?
You adapt. You adapt because, if we get to it, one of the other points is preparation. And when you prepare, and you're so thoroughly prepared that you're
that's the next one.
You're actually prepared. You get in the room, something else happens. Always. I've never tried a case where something else doesn't happen in the room. So this judge doesn't want to hear objections to email, which is the last evidence point I wanted to point to, because our evidence scholars need to come up with a rule that actually works for emails and people like me. Because we send emails and we string emails and it's but that one in the middle is the one I want, and the ones above it are hearsay and the ones below it are hearsay. So some judges say, no, I want you to blot out, just give me the one you want. Well, Judge, I'm tampering with the evidence. I'm making up a new piece of paper for you. Yeah, that's okay. Don't worry about it. Well, okay. How do we deal with the emails is something I would encourage all the bright lights to figure out because it's terrible. And judges from one to the next. No. Counsel, just give me the string emails. It's fine. Don't sweat it. Don't. Other judges, no, I'm not looking at that. It's hearsay. You know, you sent me an email, I sent it to him. It's the email, but it's attached to the one we sent to each other. That's hearsay. This is not. You adapt. I mean, I give you a million examples. I had I tried a case last summer over here, and the conversation was critical, and it was written by the secretary of the lawyer. And so there's a series of cases, old cases, that say, no, if the secretary wrote down what the other party said, and it was her job to do it, and you kept it in the ordinary court, you can get that. This judge said no.
Yeah.
I said, Judge, I don't know what else to say except, Judge Wackler said this is okay. He said, yeah, but they're not judges in this courtroom. I said, you're right, Your Honor, we'll move on. And you let go. You let go. Evidence and judges, very, very difficult subject matter. I would never say a word about a judge who's sitting and earning lousy money to listen to all of us. But I would also say there are many times in my life where I've struggled with why are we doing it? What do you mean? What is it you mean to say? But you need to adapt to that. That's a variable in your case, no different than you tripped and dropped the water all over your argument. You can't see your pieces of paper. I mean, you adapt.
Let's talk about preparation.
I think preparation, next to burden of proof, preparation is probably the most important thing that somebody who wants to litigate needs to understand. Now, you put me in a group with Henry Miller, which I don't belong in a group with Henry Miller. Henry Miller is an idol of mine. Henry Miller is probably one of the last living trial legends that we'll ever see. Henry Miller does things and gets away with things that I'm amazed at. I'm amazed that he is he's an icon in the courtroom. And if you ever get the chance to see him, you really need to go out of your way to watch him at work. He's a master. Henry is not of the view that you should come to court all the time with a notebook and any questions that you need to utilize. I am of the view that you need to do that. And I say that for a couple of reasons. When I'm done preparing for a case, I have a plan. That's my game plan. We've got our plays lined up. Okay, we've got our witnesses ordered. We're going in the room. This is the plan. Now, something invariably happens in that room that takes you away from your plan. And you need to have the confidence to be able to think in that room, in snippets, in periods of time. Because you can't walk into a courtroom and say, I'm going to think my way through this, and I'm going to baffle a judge with my brilliance, and it doesn't work that way. You don't have that luxury. I don't. Maybe some of you are gifted in the way that you can think and talk at the same time. Very difficult process. One of the things that happens to me is as I get into this, I sometimes see the pages in front of me from my trial book.
Thank you.
So it frees me up to look at you, juror number 1, and 2, and you're asleep number 3 and 4, and I can observe as I'm doing this because I see the pages, I see what's in front of me, but I also need to be conscious of what the judge is doing, and so I value the time to prepare. And I feel comfortable when I get to a podium, and this is a little unusual, because usually I'm very often at a podium, and I can use the freedom of preparation to walk over to the jurors and ask that most important question right at the end of the box. So we're all kind of looking at the witness together, or I can get away from my podium and go and start attacking this guy right here because he's a liar, and I'm going to prove him a liar one question at a time. And I can use the distance between us to build a crescendo that you'll actually get interested in. I'm not an actor, but I know my way around the room, and I know how to build momentum. I can get everybody quiet in the room, not because it's me, but because it's interesting. And it's interesting because I've thought through, how am I going to put you in a box that you're just never going to be able to get out of? How is that going to happen? So that's the value of preparation. And if you've already done your homework on the burden of proof, you know what you need to do to prepare, right? Because your elements are there. You know what you need to establish to get that defense or that claim. Preparation. And I was going to bring some props, and I didn't. You actually need the books. You know that CPLR? You need to have one of those on your desk. You need to have, CPLR, Civil Practice Law and Rules. Well, 2 books together, I guess, in '64. And because it was stupid to have 2 books of rules, so we put them all in one, and that's why sometimes you see statute signs or R rule signs, because they were brought from 2 different sources. We're back to 2 books again. We've got the CPLR, we've got the NYCRR court rules. You got to look at them. In order to look at them, they really need to be at your desk. And as you're mapping out your rules of evidence presentations, you got to have the rules. Richardson, McCormick, Mushlin. Those are the guys. There's no others. Richardson, McCormick.
I have a copy.
Thank you. It's small.
It's small, but it's good. It's good.
Those are the people you need to rely on. They've written eloquently. They've considered more things than our brains collectively can think of, and they're right. They're right on the button. So preparation to me is everything.
But here's what I want to, if you could just spend just a moment on what happens when you've done all that preparation, and as you say, I totally agree, something else always happens. I mean, I never went to court, ever, where something didn't happen that I hadn't anticipated, right? Something that, so how do you handle that if it's and usually it's something that isn't very favorable?
Sometimes.
Sometimes. So what is your advice when that happens? How do you not get thrown off course? How do you make the best of it? What do you do? Is there anything you can say that would summarize how to handle those situations?
One of Henry Miller's rules is, what do you give, what do you get? What do you give, what do you get? And by that he means it's a trade-off every time, every event. If it helps you, you dwell on it. If it hurts you, you accept it and you walk away from it. In every case, you get a punch. Every case, you get a. It's just the client or the facts, or it's just
or the judge.
Or the judge.
Right.
Yes, Your Honor. I'll move on. Done. Like it never happened. And you immediately get away from it. If it helps you, it's how it helps you.
Do you think there's a value in never showing that you are surprised? Do you ever?
Well, if you're surprised, I would argue you probably haven't prepared.
But you just said something else always happens.
Surprises are different. Surprises are different. You got the witness that you didn't depose that's coming in, he's going to wipe you out. You didn't prepare. Something else always happens. I'm cross-examining this woman, Westchester Supreme, and I got her. Judge doesn't know I got her yet, but I got her. Older woman, polite. And as I'm questioning, the judge finally says, no, madam. he's asking you whether or not, whatever, and you're saying no, and I need to judge your credibility, and shouldn't the answer to that question be yes? And she says, no. Mr. Halpern, let me inquire. Yeah, of course, Your Honor. And I sit down. Mr. Judge wants to ask questions. I'm right where I need to be. Let's see how we do it. Madam, you're not understanding this question. Let me try this one more time. No, she says. All right, Judge says, out of deference to you, because this is a very critical moment now. You sit there just saying, thank you, God. I'm going to ask you one more time. She gets the question. She leans into the microphone. The lawyer, where's her lawyer? Judge, could we have a recess? Maybe she's not understanding. Could I, anything? The lawyer's just quiet, doesn't do anything. Instead of just saying, no, Your Honor, the dog ate my lunch, I don't understand, could I take a break, anything, she leans into this microphone and yells at the judge, no! Screaming. What do? I'm just looking down thinking, I wonder how long I can get away with doing nothing. How long can I wait until we move on from this event? Can I lean over and pull up my socks? Yeah, I can do that. Can I lean over and say to the guy who's with me, are you having fun? Isn't this unbelievable how we're doing right now? You know, and that happened. And it got worse. The judge got so mad he called us in the hallway. Two lawyers, two of us, non-jury trial. We're standing there, and he says to me, he says to the woman on the other side, he says, what kind of nonsense, I don't say exactly what he said, what kind of nonsense is this? Do you want me to judge credibility based on this performance? No, let's pretend we're all the lawyers for this woman who just clearly screwed up. Judge, I'm so sorry, I don't know what it is. Could we take a 5-minute recess? Anything. Say something, for crying out loud. You know what this woman says to the question? Do you want me to judge credibility based on this drivel? She says, yes. He says, then I will. Not even close. Not even close. I thought I was going to lose tens of millions of dollars because we owed it. $300,000. I lost. We owed, I don't know, $17 million. That changed in that movie. So, is that a surprise? No. Is that luck? Yes. Have I gotten, Mr. Halpern?
It was a surprise for the other person.
Have I gotten this gentleman I'm picking on here? I was cross-examining in New York Supreme. The guy's a liar. He's a blatant liar, this guy. I'm pointing at you, and I don't mean you any disrespect, of course. And I'm going up there, and I'm banging on the table, and I'm putting documents down, and this guy has a little angina box, we learned, a little pill box. And as I get closer, he pushes it up and puts it on the table, and finally, this is Judge Altman, who's now no longer a trial judge. She says, what's in the box? Oh, these are my angina pills. Well, what do you need them for? This guy's going to give me a heart attack. So, the guy said, all right, Judge. She looks at me finally, and I'm pounding away. She says, Mr. Halpern, if you give this man a heart attack in my courtroom, I will never forgive you. Is that, you talking to me, Your Honor? This guy is stealing from my client. Mr. Halpern, if you give him a heart attack, I'll never forgive you. That was a little surprise. But so that's a negative, that was a negative. So I had to withdraw, I had to go back, I had to revamp, I had to get away from the witness, I had to change my demeanor, I had to change my tone, and be more respectful of this awful liar who, you know, was stealing. So something always happens.
And you gotta be ready for it.
You gotta be ready for it. And from my view, I would rather have my plan, because when I'm done, I know I have a plan.
And I guess, so do you plan for that? Do you know what I'm saying? I mean, you make room in your mind for the idea that something like that's gonna happen. You're on the pills or something's gonna happen. You don't know what, but something.
It's our next point. Okay. It's our next point.
Right.
How does it look?
Okay.
Let's leave the paper aside for a minute. How's this going to look to a judge? The guy knows nothing about it. Very often, the people who are disputing, the litigants, are making 15, 20 times what this judge is making. He's your trial judge. He's a civil servant on some level. He's a member of the judiciary. It's not the most lucrative career monetarily in the world, but I would argue is extremely lucrative intellectually. It's a devotion. Some of them don't even know why they're there. Some of them love the job. How does it look to this judge is something that you can't always gauge. You can read every opinion the judge has written. You can find out what associations he's in, who he hangs around with, what he's written, where he goes. There's lots of things. You can find out if he has a mortgage on his home if you want to. There's lots of ways to find out who your judge is, and that's part of what you do as a lawyer. But how's he going to react? You know, you can try to gauge it, but you can't be certain until you're there. So you try to plan for alternatives to a presentation. Sometimes you try it out. Sometimes you do it aggressively. Sometimes you do it meekly. Sometimes you reorder your witnesses. But how does it work is irrelevant. So a pregnant pause. Woman, I'm sitting there saying, thank you, God, thank you, God, thank you, God. And how long can I wait for the judge, for his mind to desire to move on to something else? Because it's persuasion, it's persuasive. So if you argue that pregnant pauses, meaning a pregnant pause is not anything more or less than a period of time until the next thought is going to come in the case. A pregnant pause can come on a break, at lunchtime, at the end of the day, Fridays. Now probably mostly Thursdays, because a lot of judges don't try cases on Fridays. So it's the last thought you're going to give that juror, that judge, before you recess. It's the thought they're going to carry on their way home. It's the impression they're going to have. You don't want those pregnant pauses going the other person's way, the other side. You got to fight to get to that pregnant pause. You got to order your proof. You got to worry about the clock. I'm going to get the next witness. Your Honor, I'm done with this witness. I'd like to take the next witness out of order. If I couldn't, I'd like to just get him started for an hour, because you know that it's Thursday at 3 o'clock, and this is going to be powerful stuff. How you order your proof, how you fight for your pregnant pauses, how you appear, how you look. How do you look? You know? Some of you are students, you look like students. Some of you are lawyers, you look like lawyers. You know? Some of you are first-year students because you look like first-year. Some of you are third-year students. Some of you are young lawyers. How do you look? What do you look like? You look okay? You look proper? You got your tie on straight? Is it down, pulled down? Because you don't, you're in a court, your tie's a mess. Is your suit clean? You know, is you shine your shoes? Your hair combed? You have to be good looking. You have to be well dressed. You show up in that Brioni suit because you're now making money. You're making $2 million a year and you can afford an $8,000 suit. Good for you, but don't wear it to a court. Nobody else is wearing that suit. That timepiece, if it's a Rolex and you're my witness, you'll never wear that in a court. Nobody else has one. So why should you show up? Because they're going to look at you, oh, you're some hotshot guy. That's an impression you're creating. You're creating an impression. Do you want to wear a white shirt or a blue shirt? There are articles written about what color shirt you should wear in the court. There are. You can find it.
What color?
White. White's the color of the day. If you want to grab everybody's attention, you wear a red tie. So look at your tie. If you're having American flags on your tie, which this one happens to be, it'll take you a while to figure out they're American flags, so you'll look at it a few times. It means you're paying attention to me.
Is that why you wore a red tie?
That's why I wore a red tie today. I wear a button-down shirt because I think I used to wear cuffs, and somebody made a comment to me in Pittsburgh one time, you know, you're the only guy in the room with cuffs? And I was like, wow, you're right. Judges are wearing cuffs. What? Well, who am I? I mean, cuff-length shirts are nice, but so you know, do you want to appear differently than your judge and jury? No. Does it mean you should go out and throw away all your nice clothes and buy crappy clothes? Of course not. How does your witness look? You can't vouch for the truth in the courtroom. I can't vouch for Mike Mushlin's integrity. But I can communicate with him in a way that I'm vouching for his integrity. He's not Professor Mushlin. You've been at Pace for how many years? And before that, you were a litigator. And academia, I mean, you're helping young people learn their trick. Well, what am I doing? I'm in a simpatico way trying to elevate the credibility of my witness. But if he looks like a freak, he's got the striped purple thing going down the back of the hair, which I have no disrespect for, and he's got, you know, this big mama diamond ring that is just 10 carats of gold. I don't judge him. But if you're coming into my world, rings gotta go. I've had people look at me in President's Club break and say, you want me to do what? Yeah, I want you to take the Rolex off. I want the pinky ring off. I don't want the fancy, you know, the monogram. My shirts are monogrammed. My shirts are monogrammed. I'm successful at what I do. You need to know that. If you don't have a monogram shirt, you're not successful? No. You'll see. It's a little thing. It's not a big thing. It's not ostentatious. Yeah, I'm good at what I do. Yeah, I can afford to put my initials on my shirt. But I'm not a big shot. I'm not a big shot. So those things, those little things about how does it look? Briefly taper.
Yeah.
How does it look? You know, oh, thank God I'm done with this thing. 2 nights, I'm so tired of looking at this damn thing. It's not justified on the right side. The footnotes, because I have a word limitation, are in such small font, nobody in America is going to be able to read these goddamn things. But I got to stay within the page limitation. No good. No good. Law clerk. I read briefs. 2 years. 7 days a week. I appreciate a lawyer, when I was doing that job, who says this case stands for this proposition. Most of you don't do that. You make it up. And by the way, the citation, I got the page wrong. No. So I am a little older. We didn't have Lexus when I got out of law school. We didn't have Lexus. We used books. And I would encourage that books are still a good thing. Computers are not always the best thing. Books still count. And you should know how to use the books, even though you're probably better at the computers. Certainly anybody in my generation, certainly me. How does it look? I just submitted, I was telling Michael today, I got a summary judgment motion that is complicated. I have this much in evidence, documents and testimony that I'm going to put in. Here's the document, Your Honor. Here's the deposition testimony authenticating the document as prepared by this witness. The handwriting is his. It's this much. I'm saying, you know, I don't want to scare a judge. Like, you know, he's going to look at this and say, what are you moving for summary judgment? We need a trial. So we thought about it. We said, Well, if we double-side copy, it's this much. Same evidence, looks better, looks better. My brief backs are yellow, not like this yellow. They're the brightest yellow you've ever seen in your life. They're not blue backs, they're yellow backs. So when I go in that clerk's office because I lost the damn motion that, you know, you filed and I can't find it, I can stand there and say, it's there. It's there. How's it look? Some judges want tabs. Well, try the case. Binders, got to pick exactly the way the judge said. I don't like your binders, Mr. Halpern. Well, Your Honor, it's 7:15. I'll have replacement binders in the morning. What does Your Honor like in binders? How's it look? How do your papers look? How well written are they? And what do you need to do to improve them for the next time? Right side justified. Not too many words. Pride in putting your name to something. Your reputation counts today.
We've gone through half the lessons and
Oh boy.
we almost have no time left. Let's try to get through quickly and leave some time for discussion. But there are some very important things that I think
So the most important ones, let's kick them off quickly.
Yeah.
Number 8, your reputation is everything. Judges talk, lawyers talk, clients talk.
Why is your reputation so important?
Your reputation is important because if you're reputable, the judge who you've appeared before, when you appear next, knows who he's dealing with. He respects your opinion before you've opened your mouth. You're honest, you're truthful, you don't lie, you don't tolerate nonsense. He knows he's got a real guy there. You show up having never been in the room, I'm already at an advantage. I've already got an advantage. And by the way, these judges, you know, they're human beings. They go to lunch, they go to dinner, they play golf, they talk to each other.
What would you like them to say about you? And is it different? Would you want judges to say something different about you than clients would say about you, than other lawyers would say about you? What would you want judges to say about you?
Hardworking, honorable, excellent trial skills.
What would you want clients to say?
Got me a great result.
What would you want lawyers to say?
Phil, can you handle this matter for me? I had this case with you 10 years ago, and you just stood out in my mind, and it's complicated, and I had a lot of respect for the way you handled yourself. Would you take this matter from me?
To get those 3 different messages, would you be doing the same thing?
Yes.
You're an officer of the court. I'll talk about that.
A very important concept. You're an officer of the court. You're an officer of the court in the room and out of the room. We have new rules. The Code of Professional Responsibility has changed, right? You know more about it than I, as the students here. But there's one rule it's become a real difficult rule for someone in my seat to deal with, and that is the false swearing, the untruthful client. Clients lie all the time, sometimes intentionally, sometimes unintentionally. An officer of the court needs to maintain objectivity at all times about what's going on, what's allowed, what's not allowed. We have a situation in my office this week where a lawyer interviewed a witness, the client, and a non-party witness. These were loans, right? Yes. Well, where are the loan documents? Well, we signed them last week. Well, why did you sign them last week? Well, we got scared. We knew we were going to be in a lawsuit. We signed them last week. Okay. And by the way, here's the QuickBooks. We made entries that each one of these things was loans over a period of 9 years. Who would do that over 9 years if they weren't loans? It was pretty good evidence. It's enough for a judge to decide. Well, turns out that the other side got a hold of the earlier version of the QuickBooks, and all the things it said were loan, loan, loan. And the earlier rendition were gift, 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 gift. And he's now going to court to tell the judge that this guy who said they were loans, client, not us, he's a liar. So now, you've got the client who said they were loans, and here's my evidence, and we relied on those QuickBooks. The other side has the earlier version that says they're gifts, and of course that's the issue when they loans are gifts. Reasonable remedial steps. Those are the words, I guess, that are operative. The lawyer shall take reasonable remedial steps to notify the tribunal, the judge, of the false swearing. Very difficult issue. But if the issue is, all I need to do is comply with the rule, because that's what I'm obligated to do, everything else becomes easy. Oh, I can't protect the client. I've got to be reasonable. I've got to try to put it in the best light, but I've got to notify this judge that, in fact, the client lied. The client lied. So I think you're an officer of the court.
Have you developed a way to determine whether someone's lying or not?
Yeah.
You have?
Yeah. You want to know it?
Yeah, I do. I really do. Even though we're short on time, I really want to know how.
If my wife were here, you'd say, "Oh, he's full of blood." I look at you, and I have an instinct about whether you're telling me the truth. I don't know whether it's the way you conduct yourself, or how you sit, or the way you answer my questions, or the eye contact that we have, or the plausibility of what you're saying. But I can tell you for sure, if you're trying to blow smoke my way, I have an instinct about it, I think. And frankly, I rely on it. So I've built up a confidence level that says, no.
Is that as important in your practice, this ability, do you think?
Distinguishing between truth and untruth,
Yeah.
truth and fiction.
Yeah.
It's very important. It's very important to be able to know that the plan you're making, the proof you're offering, is truthful. I don't think it's indigenous to me. I think, 30 years into your careers, you'll see if somebody's trying to lie to you, you'll spot them. You may not get it right away.
What about the person that in the interview with you is looking to you to figure out what they should say? Do you know what I mean?
The articulation of their claim or defense, or the manner in which
If I said it this way, would I win? Without saying that.
This is a subject that you and I talked about.
Yeah.
It's one of the most important undeveloped subjects that we have in our truth searching. It's the subject of, well, how do I say that? How do I say those words? So we can parse. We're lawyers, so we can peel the banana, we can shade it, we can grade it, we can lump it, we can. But laymen, they don't have that dexterity with language that we have as lawyers. So when I get that question, I get it all the time. So I say, well, let's see, what's the truth? What's the truth? I hit the guy right in the jaw because he got me so goddamn irritated. So that's the truth then. You hit him. Yeah. Did you hit him hard? Yeah. You were angry? Yeah. Did you intend to hurt him? No. Hey, hit him hard? You didn't intend to hurt him? I meant to hit the wall. If I say I meant to hit the wall, but I hit him in the jaw, is it better?
Yeah, there you go.
No, it's not better. Why did you hit him? Do you know what this guy said about my kids and my wife and my mother? And I lost my temper. All right, you lost your temper. So I don't put words in people's mouths. I clarify what happened. How did this transpire? I can improve your memory by giving you pieces of paper and say, well, you wrote this on this day, what?
But you're forcing people to be honest, am I right? That's what I'm hearing you say.
I require honesty.
And that takes some moral courage, moral effort on your behalf in some ways,
I'm
right?
an officer of the
What is it
court.
that, is that what
I'm
compels
an
you?
officer of the court. I'm not going to permit someone on my watch to lie to me.
So
And
even
I'm
when
not gonna-
it might help you.
No.
Okay. We've got 5 minutes. I don't know what to do. There's so much. I really wish we had more time, but we don't. So I think what I'm going to do is you have the materials, and I'll open it for questions for 5 minutes. This gentleman has his hand up first.
You spoke about the burden of proof. One of the things that I find extremely vexatious is very often there's a discussion between the burden of proof and the burden of coming forward.
Yes,
Could you talk a little bit about that?
I can.
The burden of proof,
Burden
the
of
burden of
proof
going forward.
versus the burden of production. The burden of proof and the burden of production. The burden of proof is on someone. It's on someone to prove the elements of their claim or defense. The burden of production is who speaks next. Who speaks next? The easiest one to say is the Title VII case. You're in a protected class. You were employed by an employer that has more than 50 employees. And you say you were discriminated against on the basis of your gender, whatever, and you were damaged. That's all you have to say to make a prima facie case for Title VII. You have the burden of proof, but the burden of production then shifts to the employer to come forward and say, I fired him because I had a legitimate, non-discriminatory reason. The guy was terrible. He couldn't do his job.
Let's get another question. I'm sorry. I interrupted you.
It's okay. We'll finish afterward. Then the burden of proof shifts. The burden of production shifts back to the person who has the burden of proof.
No, but the burden of proof.
Yeah, but he can be a
the
law
burden of
professor
coming
on this.
forward.
This-
The burden of coming forward shifts.
Burden of production shifts.
Well, you call it.
But the burden of proof always remains on the plaintiff.
Listen, I heard a lecture once by a professor who said no one knows what the hell not to say that there isn't meaning to them, but I want to get another question.
Yes.
You always look up the judge's bio, especially when you use venue somewhere to find out his background.
Do I look up his bio?
Yeah.
I read every case he's written on the subject. I find out what groups he belongs to, what's his politics. Is he married? Has he got kids? What did he do before he was a judge? Anybody that I know who might have appeared before him? Yeah, absolutely. Yes.
When you're talking about sort of the ethics of being a lawyer, and you always want to be like the most respected man in the room in front of the judge.
Most reliable.
Most reliable. If you run into a situation where you have a client who's lying, does it end up being a race to the courthouse to see which lawyer can get there first and show the judge, this guy lied in this paper. No, judge, you didn't lie. I just found out this information.
You never race to stab yourself in the heart. So nobody races to find out who's the liar first. But you need to think carefully about how you're going to explain to your judge that your client on your watch lied. A very difficult issue. It's not susceptible to easy, not everybody runs to the courthouse. You got to think how you're going to explain to your judge that your client just lied. And you've got to separate yourself from your client because you're the officer of the court, and you need to make that judge comfortable that you took every reasonable step you could to ensure that the truth was being told at the time.
Well, I wish we had more time, but let me just say, I think we've heard from a master this evening, and I'm very grateful.